Prenuptial Agreements Guide. Who needs a prenup? How to make one, and what the law allows. A prenuptial agreement, aka prenup, is a written contract created by two people before getting married. In some states, a prenup is called an antenuptial agreement or a pre-marital agreement. Some courts allow the word contract and agreement to be used interchangeably, as in prenuptial contract. Keep in mind that an agreement made during marriage, rather than before, is referred to as postnuptial, post-marital, or marital agreement. Any couple contemplating marriage can enter into a prenup if both parties agree to all of its terms. The main goal of most prenups is to establish rules and guidelines for splitting assets and debts should the marriage end in divorce. Find out what you need to know if you are considering a prenup. Welcome back, folks, to another edition of the Awesome Sweetie Kiwi Show. How you doing today? I hope you are doing fantastic. I'm doing terrific. If you are doing as marvelous as I am, go grab a cup of coffee or tea or vodka and let's roll. Today, I want to talk to you about Prenuptial Agreements Guide. I want to talk to you about who needs a prenup, how to make one, and what the law allows. Who needs a prenup? Let's talk about that. Contrary to popular opinion, prenups are not just for the rich and famous. I hear this a lot. People think, oh, I don't have any money. I'm not wealthy, so I don't need a prenup. You may have to have a prenup. While prenups are often used to protect the assets of a wealthy fiancé, couples of more modest means are increasingly turning to them for their own purposes. Let me give you a few reasons why people may want to have a prenup. For example, pass separate property to children from prior relationships or prior marriages. So a married couple with children from prior relationships may use a prenup to spell out what will happen to their property when they die, so that they can pass on separate property to their children and still provide for each other if necessary. Without a prenup, a surviving spouse might have the right to claim a large portion of the other spouse's property, leaving much less for the kids. Also, you can use a prenup to clarify financial rights. Couples with or without children, wealthy or not, doesn't really matter. They may simply want to clarify their financial rights and responsibilities during marriage. You can also use a prenup if you want to avoid arguments in case of divorce. If you want to avoid potential arguments if you and your significant other ever divorce, you can do so by specifying in advance how your collective property will be divided and whether or not either spouse will receive alimony. A few states will not allow a spouse to give up the right to alimony, however, and in most others, a waiver of alimony will be scrutinized heavily and would not be enforced if the spouse who is giving up alimony didn't have a lawyer. You might also need a prenup if you want to get protection from debts. Prenups are great when it comes to protecting spouses from each other's obligation, and they may address a multitude of other issues as well. Let's talk about if you don't make a prenup, what will happen? The world's not going to go into end. If you don't make a prenuptial agreement, your state's law, or laws for that matter, determine who owns the property that you acquired during your marriage, as well as what happens to that property at divorce or death. So property acquired during your marriage is known as either marital or community property, depending on your state. State law in this case may even have a say in what happens to some of the property you owned before you were married. Under the law, marriage is considered to be a contract between the married couple, and with that contract comes certain automatic property rights for each spouse. For instance, in the absence of a prenup stating otherwise, a spouse usually has the right to share ownership of property acquired during marriage, with the expectation that the property will be divided between the spouses in the event of a divorce or a death. So here I'm talking about real estate. If you buy a a house or a condo, then the rights to that condo will be equally divided. State laws also assume that a spouse usually has the right to incur debts during marriage that the other spouse may have to pay for, and share in the management and control of any marital or community property, sometimes including the right to sell it or give it away. If these laws, they're called marital property, divorce, and probate laws, aren't to your liking, it's just time to think about a prenup, which in most cases lets you decide for yourselves how your property should be handled. It is also important to mention here that the conversation about a prenup should not be started a few days or weeks before a wedding. You want to start a conversation about a prenup even if you're not contemplating a wedding. If you live with someone and you've been living with a person for a while, then you want to start the conversation. Now, this should be part of the what I call the risk management conversation, where you're sort of outlining financial matters that are important to you and financial matters that may be important for the relationship. So if you don't make the prenup, if you don't want to make a prenup, at least you would have discussed this with your partner and being on the same page in terms of the significant items. I want to talk to you now about making a valid prenup. If you decide to make a if you decide that a prenup is a good option for you, how do you make a valid prenup? As prenuptial agreements become more common, the law is becoming friendlier towards them. Traditionally, courts scrutinized prenups with a suspicious eye because they almost always involved a waiver of legal and financial benefits by a less wealthy spouse, and they were thought to encourage breakups. As divorce and remarriage have become more prevalent, though, and with more equality between the sexes, courts and legislatures across the country are increasingly willing to uphold premarital agreements. Today, every state permits them, from New York to California, from Illinois to Texas. However, a prenup that is judged unfair or otherwise fails to meet state requirements will still be set aside. Courts will look carefully at prenups. Therefore, it is important that you negotiate and write up your agreement in a way that is clear, understandable, and legally sound. If you happen to draft your own agreement, which in all cases I recommend, you will want to have separate lawyers review it and at least briefly advise you about it. Otherwise, a court is much more likely to question its validity. In other words, what I'm saying here is you and your partner wants to hire two separate lawyers, each having their own lawyer. So you draft what you want, you draft what's important for you, you lay out all the key elements you want to have in the will, and you have your attorney scrutinize it, peruse it, and look at the documents in and out and advise you as to its validity. You want your partner to do the same thing, and then you both merge under the tutelage of both lawyers. You want to merge both documents and have, quote unquote, a common denominator prenup. That way, a judge will validate the documents because he or she will think it's fair, it has been thoroughly discussed, and both partners and both spouses in this case have not signed the document under duress or have not signed the documents under some kind of unfair processes. And this is very important if you want your agreement to be upheld in court when the right time comes. Of course, nobody wishes to have a breakup or divorce when they get married, but things happen, life happens, but you got to think about you have to plan for the unforeseen. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We are also having a conversation today around the Prenuptial Agreements Guide, and I'm just telling you who needs a prenup, how to make one, and what the law allows. How do you draft your own prenup? Every state has its own laws on what you can and cannot include in your prenup agreement. So before you sign, you want to make sure you check with an experienced attorney, a legal expert in your state, to verify that your contract is valid. What can you accomplish with a prenup? As I said, everybody knows that when you get into a marriage, when you get married, it's for better and for worse, unfortunately. It's no secret that the divorce process can be emotional and costly. So for couples who wish to reduce the expense and turmoil that generally accompanies the legal process, you can include some or all of the following provisions in your prenuptial agreement. Let's talk about a few of them here. Identify and divide separate and marital assets. When a couple divorces, one of the first tasks is to identify and allocate separate and marital property. Separate property includes the asset a spouse owned before the marriage, or even better, were acquired through a gift or inheritance. Marital property includes assets the spouses acquired during the marriage. Typically, if you can prove that you owned the property before you got married, it will remain your separate property and the court will not award any of it to your spouse. There are two ways courts can divide marital property. In community property states, courts generally split marital assets equally using a 50-50 split. So it's very simple. They just look at the totality of assets and they just divide it by 2. In equitable distribution states, judges divide marital property in a way they believe is fair. Depending on the individual circumstances of each case, this method does not always result in a 50-50 split. Courts will consider a variety of factors to assess what would constitute an equitable division. Equitable is just a fancy legal word that means fair. Prenups are excellent when it comes to helping couples avoid a lengthy battle over physical property if the relationship ends in divorce. When properly drafted, the contract can identify each partner's separate property and confirm how this property will be treated upon divorce. The good thing is you can also decide, depending upon your circumstances, you can decide how you will split your marital estate in advance. For example, let's say if you want each spouse to receive 40 or 50% of the marital assets, you can put that agreement in writing rather than leave it to a judge in the event you divorce. You can also use a prenup to identify and allocate separate and marital debts. So first we talked about assets. Let's now talk about financial obligations here. Money can be the root cause of many divorces. We all know that, right? So if you or your fiance want to avoid falling into the same trap that many do, you can add a provision to your prenup to address debt. The essential components of a fair and valid prenup is full disclosure. It's all about being transparent. Both parties should complete a financial disclosure statement identifying all of their assets and debts. They should also attach a copy of this to the prenup contract. Like assets, your agreement should identify separate and marital liabilities and how you will divide each debt. Prenuptial agreements are particularly useful if one partner brings a significant amount of debt to their relationship. So if you or your fiance is heavily indebted before getting married, you want to list that. If you would like to ensure that you will not be responsible for your partner's poor credit habits from college or university or from a prior marriage, you can include a provision about this in your prenup. Other elements you can include in a prenup is spousal support concerns. Now, you have to understand that in any relationship, in any marriage, it is common for one spouse to earn more than the other, or for one to stay home and raise children rather than follow a typical career path. Depending on the length of your marriage and your state's divorce laws, the lower earning spouse may be entitled to financial support from the other. Spousal support can include temporary or long-term payments, and the amount depends on what the judge decides. And again, this might not always be the best plan for you and your family. So you have to think about those elements beforehand. If you like to avoid the uncertainty of a judge's discretion, you can include a provision covering spousal support in your prenup that will financially protect you if you get a divorce later. If you earn substantially more than your spouse before the marriage, you can add a clause that limits spousal supports later. Keep in mind, though, that all prenup clauses are subject to a judge's review. So if your agreement is not fair or seems a little dodgy or retaliatory, the court could eliminate that provision. They could just strike it down. You can also include special consideration if you have children from a previous marriage. So if you are remarrying and either spouse has children from a previous marriage, people call this a blended marriage. Your prenup should include a provision that will ensure that your children can inherit their share of your estate in the event of your death, if that's what you intend. In a prenup, though, one or both spouses can give up the right to claim a share of the other's property at death, perhaps in exchange for an agreed upon amount of assets. It is critical for you to follow through with your estate planning wishes by creating a will or a living trust after discussing your plan with an experienced estate planning attorney. We have covered the topic of living will, living trust, basic will in other shows, so you might want to double check those shows to have more information. You can also use a prenup to keep property in the family. Let's say you have separate property that includes an item that you would like to keep in your immediate family, like a family heirloom or inheritance. You and your spouse can agree that it will remain in your family after a divorce. If you expect an inheritance or other property later, you can also include a provision that specifically addresses future gifts or inheritances. Now, this may be unnecessary, rather, depending on the laws of your state and separate property laws. But you still want to make it because it specifies and makes your wishes explicit, and especially if you put them down in writing so that you have a clear understanding. Everybody's on the same page. You and your partner are on the same page, and things can happen more smoothly if the unforeseen or the unfortunate event of a divorce were to happen. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. If you love the show so far, if you appreciate the clarity and quality of the content so far, please consider subscribing to our channel and turn on the notification bell so you can be aware whenever we release a new show. And we do this every single day, rain or shine. I want to talk to you now about what you cannot include in a prenuptial agreement. Whether or not you create a prenuptial agreement is up to you and your spouse. It's not mandatory. Some couples don't want to do it, some do. However, even couples with a prenup will need to go through the formal divorce process and follow state laws. There are multiple legal issues that the court or spouses will need to decide before the judge can terminate your marriage. Although a prenup may include provisions for property and debt division, spousal support, and even inheritance rights, there are some critical topics that you cannot control in a prenup, and you will need to address during the formal divorce process. You will not be allowed by state law to include those elements in the prenup. You just have to go through them. Number 1, child custody, parenting time, and child support. Divorcing parents can work together to divorce the way they want, but they also need to decide how to handle child custody, parenting time, and child support. However, the court will need to approve your agreement before implementing it. You cannot resolve these issues in advance in a prenup. It just doesn't happen. It wouldn't happen. Now, the court will always have the authority to decide how to allocate child custody and sell child support by evaluating what's best for the children at the time the issue arises. All states in the union have a specific set of factors that court will consider for custody decisions, and to set the amount of child support the non-custodial parents will pay each month. If you're not confident that you will agree with the judge's decision, You may want to consider participating in mediation with your spouse before asking for the court's assistance. Another thing you cannot include in a prenup in advance is daily tasks or spousal duties during the marriage. So couples contemplating marriage may want to include provisions in the prenup that establish which spouse will take out the trash, clean the house, or address other non-financial duties. But the law specifically prohibits those clauses. Any clause that requires a spouse to complete a task or a function in prenuptial agreements is forbidden. And it may even encourage the judge to take your entire agreement less seriously. If you like to establish specific responsibilities for each spouse, you can include your wishes in a separate document. It is essential to understand that the court will not enforce this type of arrangement, no matter the states, no matter where your divorce is about to happen. So if either spouse decides to ignore the provisions, the other doesn't have much recourse with the court. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another section of the Sweetie Kiwi Show. We are talking here about Prenuptial Agreements Guide. This is a guide about who needs a prenup, how to make one, and what the law allows. If you love the clarity and quality of the show so far, please consider subscribing to our channel and turn on the notification feature so that you are notified in real time whenever we drop a new show. Also, please comment below, ask questions that are relevant to the topic, and we'll be very happy to get back to you. Share this content and like it. Should you hire an attorney? This is a good question. Before I even answer the question, please remember that this show is not about giving any legal advice. We're not lawyers. We have gathered information that we are presenting to you and sharing with you. Every state has separate rules for prenuptial agreements. If you're not familiar with your state law or you're not comfortable interpreting the rules, you should hire an attorney. In fact, in some states, each of you may be required to have your own attorney review your prenup. An attorney provides independent legal advice. It's easy to understand that you should hire one lawyer, but why two? It's common for courts to scrutinize your prenuptial agreements, sometimes very closely. If you want your agreement to remain valid, it's wise to hire two independent attorneys to help you and your spouse draft the ideal document. As with all legal matters, remember that you cannot use the same attorney to represent both of you in negotiating and drafting a prenup. They have to be separate. They have to be independent. They have to be different. If you present the court with a prenuptial agreement where only one party had an attorney, the judge may see this as a red flag. Remember, there is the whole notion of equitability. The judge might think the whole agreement was not equitable in the first place, was not fair, or maybe that the partner, the spouse who didn't have an attorney, had to sign the contract under duress, under stress, under pressure. So if either spouse entered into the contract without understanding the benefits and risks, which can happen when only one person has a lawyer, a court may reject the contract during divorce proceedings. So when each party had the opportunity to obtain independent legal advice about the terms of a prenup, courts are more likely to determine that each person understood what the contract stated and therefore more likely to uphold that agreement in court. Before deciding to hire an attorney, talk to your spouse first. As I was saying earlier, you don't have to wait a few days or weeks before the marriage before having a conversation around prenups. Prenup communication can put your issues to rest before you walk down the aisle so you can have a healthy relationship for the foreseeable future. Talk about those things as soon as you've been living with someone for quite a reasonable time. It can be 6 months and 9 months, and you believe things are moving in the right direction and there might be a wedding down the road before, so that you are able to have great conversation, dispassionate conversation. If you want to avoid problems in the future, it's better to start first and talk about prenup to your partner aka spouse or significant other. Before you use legal services, you and your partner should discuss the terms you both want in the agreement. In most cases, both of you want the same thing, just to be treated fairly and walk away from the marriage without becoming poor or losing your separate assets. Both spouses should be open and honest about what they want or don't want in the agreement. If you have a separate independent attorney, both of you, then this is fantastic because your attorneys will help you put your desires into the proper legal form so your state recognizes it as a valid contract. How do you find a qualified attorney? One of the best ways of hiring a qualified attorney is to ask family and friends for referrals in your area. If you go to your state's website, you might also see resources to help you identify attorneys who can help you. You can go to the state bar. Some states have something called lawyer referral network. Potential clients can call a toll-free number and talk with a representative about a legal issue, and the attorney and the agent can connect with an attorney willing to provide you with a consultation for free. Sometimes you might have to pay, but it's deeply discounted. So most states have this sort of schemes in place: lawyer directories, lawyer referral network. You can contact the state bar to have more information. So you have all kinds of outlets to get information. Thank you so much for listening to this conversation. I really appreciate it. Just want to quickly recap the show here. I spoke to you about who needs a prenup, what happens if you don't make a prenup, making a valid prenup, how to make that, how to draft your own prenup, what you cannot include in a prenuptial agreement, and whether you should hire an attorney. I will see you next time. But until then, remember, stay marvelous.